Yeah, you hate the United States over the law of Mississippi, and all we call the law. Judge Alexander Preside. God save the United States, just all the court.
Be seated, please. This is case number 3:13, MJ19, United States versus Paul Kevin Curtis. We're set this afternoon for a preliminary hearing and detention hearing. Preliminary hearing is on the complaint, the criminal complaint that's been filed against the defendant, and our government's moved for detention, and so the detention hearing is held pursuant to that motion. Sometime a little while ago, I got a motion to continue the hearing from the United States, and my inclination is to deny the motion, but I will give you an opportunity to be heard on that. Mr. Who? Which one of you? Mr. Lamar?
Well,
that's fine. Let me just say for the record before we start here, we've got for the defendant, Ms. McCoy, Mr. Nielsen hasn't made an entry. Is he going to be?
He did. Yes, he did.
You have? Okay. All right. And then for the United States, we have Mr. Alexander, Mr. Joyner, and Mr. Lamar. Mr. Lamar?
Thank you, Your Honor. Yes, ma'am, we did file a motion for a continuance. As you recall, we had an initial appearance on Wednesday, right before lunch. Yesterday, right before lunch. And although Ms. McCoy takes issue with this comment, I believe that it was Ms. McCoy that asked for it to be. You initially wanted to set it on Monday, and Ms. McCoy asked that it be moved to Friday. With all due respect, our reading, this is a very complicated case. It's a very serious case. It has serious consequences. We have threats against the President of the United States, sitting President of the United States, a sitting United States Senator, and a state court judge. The threats involved explicit comments. Someone must die for what it is that they've done. The envelopes included ricin in them. The substance has tested positive for ricin. Ricin is a biological toxin that is it's extremely deadly. There is no antidote for it. We are conducting today search warrants on his residence, a vehicle. We have legal process out to Facebook. We're about to apply for another search warrant for some other internet service provider data. We have 2703D orders. In other words, Your Honor, there is a lot of data that we would like to have the opportunity over the weekend to analyze. Our reading of the Rule 5.1 is that when you have been arrested on a criminal complaint, you are entitled to a preliminary hearing. But that rule also says, under those circumstances, that you must have a preliminary hearing within 14 days if the person's in custody. I'll be honest with you, I didn't realize that we were granted that much time. But, on the other hand, we were moving for detention. And the rule, the statute, 3142, clearly states that the hearing on a motion for detention should be held immediately. However, it also provides provisions for the defendant to ask for a continuance of up to 5 days, and the United States to ask for a continuance to up to 3 days. Those 3 days and 5 days do not include intermittent weekends. So, with all due respect, we think we're entitled to it. We think that the defendant would benefit from as complete an analysis of the data that we have assembled and are currently assembling. Mm-hmm. For all we know, there could be some exculpatory materials in that. We just simply don't know. There's just an awful lot to do in a very short period of time. We have not been able, we did not even have the guy identified until late on arrest him on Thursday, late on Wednesday afternoon. I mean, not even identified, and so it's just very difficult to get the process out that you would ordinarily like. Now, also because this threat involves the presence and use of ricin, and we honestly believe that, or we wouldn't be here, that Mr. Curtis acquired that ricin, put it in the envelopes, and sent it out.
Wow.
Every person every person that is even remotely near that is subject to ingesting it. They're subject to death. For that very reason, we don't know and didn't know what was in his house. We don't know and didn't know what was in his car. Those vehicles, once we obtained the warrants, the vehicle and the residence had to be swept by hazmat trained people. I assume I wasn't there, but I assume suits and breathing apparatus and hoods. And they are in the process of conducting that warrant, the search warrant, now as we speak. I haven't heard otherwise. Your Honor, we think that the interests of justice in that, that we would be granted at least one more day up to that third day, which is on Monday. And I don't want to play with what time of the day does it necessarily begin. I'd like to have a good full day in this courtroom if that's what we need. If we need that to present the evidence, and if she needs that to refute it, rebut it, and for cross-examination. We don't see what the prejudice is to the defendant other than spending 2 more days in jail.
Jail is a prejudice.
Other than that, but the rules permit that extra 3 days, and the exclusion of the intermittent weekend.
Obviously, we have different requirements for each of these hearings and time limits on which, during which the hearings must be completed. But the detention hearing is the one, of course, that I'm always trying to do as early as possible. And inevitably, I'm trying to accommodate a defendant who's been brought in. I mean, especially where a grand jury hasn't looked at the case. So this defendant's been arrested on a warrant that was issued by me, but in order for him to be formally charged by a grand jury, or for charges to go forward against him, he's got to be formally charged by a grand jury or agree to an information. And what you're asking is that he be detained until that happens. I realize the grand jury meets next week, but
no, Your Honor, I'm just asking for a postponement, a continuation until Monday, mid-morning.
My question is this. You're talking mid-morning, and if this were not Friday, it would be a no-brainer for me, frankly. But because we could have it the very next morning. We're not talking the next morning. I know, I issued that warrant yesterday. My understanding was that the search was to be begun this morning. You haven't heard anything? I can't believe the government hasn't gotten any report.
The hazmat teams went in the morning to sweep the house to see if there was any biological or chemical agents that would injure anybody on the search team.
All right. The representation made to me at the time was that it was going to be done last night.
Okay, answer that.
And then
we've got about 5 different
morning.
AUSAs handling different aspects of it, and so if I'm in error with that, I think Mr. Dorn.
In chambers for that conversation, Your Honor, the sweep that was referred to was a tactical sweep. That is to make sure, as it was described to me, there's no two-legged or four-legged threat in the dwelling. Tactical sweep to ensure that that's done with people wearing hazmat suits. They then retreat from the dwelling, and then the actual people who are coming in to test for biological agents go into the building the first thing this morning, which did indeed happen. That search was delayed, I believe, because of the initial finding of what they thought was a suspicious package. I think that ended up not being anything, but that delayed further. The search has been ongoing all day, Your Honor, but it's still ongoing. There was an initial delay because people were brought in to look at what they thought might be some type of device, which I don't think was the case.
Well, does that have something to do with the fact that you need a continuance here? The fact that the search is
Yes, ma'am, absolutely. That's what I mean by being able to analyze data and materials seized during the search, and data and materials that that are trickling in from the legal process. And we'd like to take a deep breath and take a good look at it and present the best evidence that's available to this court for that determination. Share that with the defendant and defense counsel, and I personally think we would all benefit from that. We have all been working around the clock since this began.
All right, thank you. Ms. McCoy?
Yes, Your Honor. May I proceed, Your Honor?
Yes, ma'am.
Thank you. On behalf of Mr. Curtis, Your Honor, Mr. Lamar, just kind of casually says, what prejudice is there? Well, the prejudice is this man has been taken from his home and his family, and he is now incarcerated. He hasn't been able to see his children. His dog escaped during the melee of his arrest. There is a lot of prejudice. That's why I objected to this. Generally, as Your Honor knows, I'm very workable. I do not object. The reason that we asked the hearing to be moved to today as opposed to Monday, generally the court is always so generous in saying, if you need time, you've got your 3 days. We didn't need time, Your Honor. And I felt like it was certainly not for my convenience. My schedule did not matter, but it was so that we could get Mr. Curtis here as soon as possible and ask this court to basically review the evidence that they have. So it was not, I want to make it clear, it was not for my convenience. It was to protect his rights. Couple of things before I move forward on my point that I do need to respond to. Mr. Lamar stated that he was not identified until, I think, Wednesday. That completely flies in the face of everything that has been said by Senator Wicker's office. Furthermore, on Wednesday night, when this man was chained to a chair for 3 hours, he was continually told that they had been watching him for a long time and they knew what he was doing. And I don't know that it matters. But what does matter is that he is able to have the charges brought against him in a public forum as soon as possible. As Your Honor knows from my response, the other reason that Mr. Curtis and our defense team is so concerned, we all have been working around the clock. And we spent over 2 hours this morning with the Chief Judge while the U.S. Attorney's Office attempted to delay this matter on a whole different reason. It was, we think he needs to be sent off for an exam. And at no time during those proceedings was it ever said, you know what, we might not be ready this afternoon. It was, we can't go forward this afternoon because he needs a competency hearing. And then as I'm preparing, I've got witnesses coming from 200 miles away. I've got everyone coming in ready to proceed. And 90 minutes before the hearing, an email pops up that says, we want to continue because we're not ready. As far as just being defense counsel and being in this court many times, it's like Your Honor said, if this were a weekday, I wouldn't even bat an eye, say no problem, but this is a little different. And I guess my question is, what possible evidence do they expect to gain prior to Monday that they didn't have when they took this man from his home? I mean, that's where I'm concerned. Mr. Lamar talks about all these subpoenas that are out, all of which could have been done without removing this man and removing his liberty. So, I guess my concern is if we show up Monday and Facebook hasn't sent all the subpoenas back in, or what are we looking at then? Furthermore, I do think it's important for this court to know that from the time he was arrested, he has consented to any search. He gave them the key to his house. He said, anything I have is yours. I'll take a polygraph. There's no, he's very much willing to cooperate in any way. And those are all the reasons that, quite frankly, Your Honor, we just feel that this is a delay tactic and that, he is going to be forced to remain in custody and not even have the chance for bond if their motion is granted. And we just feel like that they had ample. I mean, as I understand it, the burden's fairly low. As far as the preliminary hearing, the burden is fairly low. Obviously, the detention is a whole different issue, but it really does just stretch my mind that they can't move forward just with this, with a preliminary hearing and a detention hearing. Obviously, we are happy to do whatever the court tells us to do. If you want us to come in Sunday afternoon, we will. But I think my response, it was very quick, Your Honor. I apologize if there's typos or whatever. My very, very quick response, but not to overburden the situation, but it just makes me go, what? Really? We've got a man shackled, chained. I understand it's national importance. I understand that someone allegedly sent envelopes that allegedly have toxins in them. I get that. But if this is a man that did it, and they want this court to hold him, where's that evidence? And the sooner we can see it, the better, so that we can make a determination of where we move from here, Your Honor. That's all. Thank you, ma'am.
I do want to trust one thing, if I may. We're not here to delay anything at all. We weren't before Judge Mills trying to delay anything. Quite frankly, the man suffering from a mental disease and defect that might render him incompetent. That's a fact, and I believe it. And that's what we were presenting to the judge this morning. We're not trying to delay anything. As she says, stalling. We're asking for a day that we believe that we're entitled to.
I guess my concern, Mr. Lamar, is that, you brought the charges, takes probable cause to have a warrant issued. You obviously felt you had enough at the time to charge him with these very serious charges. And your agent's here. Usually I'm delaying these hearings because we don't have an agent, or the person that needs to testify can't get here. That's not the case.
Your Honor, can we put on more than a bare bones case right now?
Well, isn't that what you always wanted to, Mr. Lamar?
Well, herein is the problem. We have agents out in the field searching. We have agents out in the field interviewing people. We have agents in our office collecting and trying to process. We have agents down in Jackson analyzing and inputting data. We have not had the opportunity to sit together and to discuss what we have. Now, why did we arrest him that day?
Well, I know why you arrested him. I know why you arrested him. The problem is his having to be here in a courtroom and in a jail when you say, we've got probable cause to charge this man, the defendant is entitled to a preliminary hearing. It would seem to me the ducks should be in a row, at least for that burden at this point. And that's what's confusing me.
Your Honor, we contend we're entitled to 3 days. We'd like to have those 3 days so that we can present to you the most accurate picture that we can. It's just that simple. But yes, ma'am, I would have loved to have had 2 months to issue grand jury subpoenas and do search warrants and put all this together before we had to place him under arrest. But you don't have that luxury. That's great in a fraud case.
But we're not getting ready for this. Isn't going to be the trial either. I mean, this is just whether to hold him over for action by a grand jury and to whether he should be held in jail.
Your Honor, I'm just asking for something that I think I'm entitled to. If you don't agree with me, then we're here. I mean, that's why we're here. But
then let's go forward. If your agent is here, let's go forward.
Call Special Agent Brandon Grant.
He couldn't wait.
Agent Grant, come forward, please.
Where our firm the testimony you're about to give will be the truth and will be the truth. Go ahead.
I do.
Would you state your name and spell your name for the record, please?
Yes, ma'am. My name is Brandon M. Grant. It's Brandon. Middle initial is M as in Mark. Grant, Grant. Is everyone ready here? Yes. There you go. All right, Mr. Grant, what do you do for a living, sir? I'm a special agent assigned to the Mississippi Joint Terrorism Task Force in Jackson, Mississippi. And could just briefly describe what those duties are.
Sure, sir. My primary duties on the Mississippi Joint Terrorism Task Force is I'm a Special Agent Bomb Technician, and I'm also the Weapons and Mass Destruction Coordinator. I deal with issues involving explosives, chemical, biological, radiological, and nuclear materials. Our squad typically addresses international terrorism, domestic terrorism, and weapons and mass destruction violations of criminal law.
You don't have to get into names and name everyone, but approximately how many agents are working on this case? How many different agencies, if you're aware? And how many different locations are we in?
I would say approximately right now there's in excess of 70 agents or support personnel operating both in Corinth, here in Oxford, Tupelo, and in Jackson, sir. And the agencies include the Federal Bureau of Investigation, including the Memphis Division, the Jackson Division, the New Orleans Division, our Critical Incident Response Group out of Washington, D.C., out of Quantico, Virginia, our Laboratory Division, the Weapons and Mass Destruction Director out of Washington, D.C. We also have representatives from the U.S. Secret Service, the United States Postal Inspection Service, the Mississippi also Homeland Security, the 47 Civil Support Team with the Mississippi National Guard, Lee County Sheriff's Office, Tupelo Police Department, and I'm sure I'm missing someone, sir.
A lot of people, a lot of reasons.
Yes, sir.
All right, you're co-affiant, Special Agent Brad Dickerson with the Secret Service.
Yes, sir.
All right, did you and he submit an affidavit in support of the issuance of an arrest warrant pursuant to a criminal complaint on naming one Paul Kevin Curtis as a defendant?
Yes, sir.
Let's try to start with this thing. It doesn't necessarily work chronologically, so let's start with when Brandon Grant gets that call to go active.
Yes, sir. I was in Jackson. I believe my days are running together at this point. Tuesday, this past Tuesday, which I believe is the 15th, if I got that correctly. And I was informed that we may have a situation involving a letter at Senator Wicker's office, a letter sent to Senator Wicker's office, which was intercepted at the Senate mail processing facility in Maryland. At that time, we started coordinating with our office in Memphis and our headquarters in an effort to try to determine what was going on. We also understand that the U.S. Capitol Police had started their investigation into who may have sent this mailing and trying to identify a subject, sir.
All right. Do you have, and that was the initial letter was to United States Senator Roger Wicker.
That's the first letter we became aware of, yes, sir.
Okay. Let's describe for a little bit how the mail arrives at the office of the United States Senator.
Yes, sir. When it's delivered, it is delivered to a mail processing facility that's located off-site. In this instance, I believe it was Capitol Heights, Maryland. I know it's in Maryland. It was delivered in Maryland, and as it was being processed, they x-ray them and check them for random things. They identified a suspicious granular substance in a envelope containing a yellow letter or yellow sheet of paper, postmarked it was postmarked out of Memphis, Tennessee, on April 8th. I'm just going to check my notes. I want to make sure I got the dates right. On April 8th, yes, sir.
Okay. Addressed to Senator Wicker?
Yes, sir. And I can read it verbatim if you'd like for me to.
Perhaps so, yes. And then maybe I'll show counsel opposite, and then the judge will sit.
Sure.
Yeah, let me give you the right one. That's the Wicker letter.
Are these our copies? Okay, get up. Yeah, reports or anything that I'm going to get after 8.
of the granular substance that was found in?
I do. I don't have it with me. Actually, I think it's visible in that second photograph you have there down in the corner.
Your Honor, I'm showing in what I've marked as Government's Exhibit 1A and 1B, that being the envelope of the Wicker letter, and 1B being the contents, that is the letter itself, and visible in the lower right-hand corner is the white granular substance contained in it, just for the record. But do you recognize this photograph?
I do, sir. Yes, sir.
All right, and is that a true color picture copy of the envelope as it was received in that Maryland mail reception facility?
From my understanding, yes, it is, sir. I received it in this manner.
And is 1B a true and exact copy of or photograph of the letter, the verbiage written upon it, and the kind of off-white granular substance?
Yes, sir.
If you wouldn't mind, sir, would you read the letter?
Yes, sir. And as I said before, this letter was addressed to Senator Roger Wicker. The senator was misspelled. The E was left off at 555 Dirksen Senate Office Building, Washington, D.C. 20510. The letter states, no one wanted to listen to me before. There are still missing pieces, and missing pieces is in quotations. Maybe I have your attention now. Even if that means someone must die. This must stop. To see a wrong and not expose it is to become a silent partner to its continuance. I am KC, and I approve this message.
All right, let's talk about those passages for a few minutes. Have you learned through sources, for example, Capitol Police, yourself, other agents, the internet, what this reference to, what is missing pieces?
Yes, sir. Through different sources and methods, missing pieces, including a custodial interview with Mr. Curtis, missing pieces could be in reference to a book or a manuscript he attempted to publish or has attempted to publish involving the trade or the industry involved in body parts and organs and things and such like that, sir.
And are you aware of an incident involving Mr. Curtis and the North Mississippi Medical Center in Tupelo, Mississippi?
I am, sir.
And what's that all about?
From my understanding in reports received from other agents and also from Mr. Curtis, Mr. Curtis was relieved of his duties at the North Mississippi Medical Center after there's going to be two sides of the story. I'll give the side that the North Mississippi Medical Center provided to us. He was relieved of his duties after entering an area where he was excluded from. He was in charge of stripping floors and custodial duties and so forth. Mr. Curtis informed us that he was relieved of his duties after identifying severed body parts in a cooler at the North Mississippi Medical Center and inquiring why they were there.
Did he accuse North Mississippi Medical Center of doing anything with those body parts, or was he opining what they were doing with them?
The accusation, or his opinion, was they were trafficking these body parts on the black market.
I assume for people who might be missing an arm or a leg or a foot.
That's my understanding, sir. Yes.
Now, we're going to talk about other passages a little bit later, but this passage down at the bottom, I am KC and approve this message.
Yes.
When I believe it was the Capitol Police first started to contact Senator Wicker's staff about who KC could be. Can you describe what was learned and subsequently what you've learned?
Yes, sir. So the initial investigation was started by the U.S. Capitol Police in Washington, D.C. Upon the receipt of the letter to Senator Wicker. Approximately 1 p.m. on the day this letter was received, and I'm getting my dates all confused here.
I know you didn't have much sleep.
I'm gonna say it was 4/16, April 16th. Yes. On that day, approximately 1 p.m., an agent from the Washington Capitol Police met with the chief of staff for Senator Wicker, Michelle Barlow Richardson, or Richards. I may have her name wrong there, and inquired about obtaining a list of constituents for Senator Wicker who had the initials KC, Kilo Charlie. The original list was in excess of 1,000 names. However, they were able to reduce that list down to just over 100 by focusing on individuals that would be utilizing a postal service that would postmark envelopes through the Memphis Postal Processing Center. By doing that, they had approximately 100 names. At approximately 2 o'clock, the Capitol Police folks went back to their office and started conducting research. And it's my understanding what they did is they were doing open source research, basically plugging in KC and verbiage from the letters into the internet, I'm sure Google or something along those lines. And lo and behold, they come up with a Facebook page for an individual named Paul Kevin Curtis, and when they get that, they start seeing some similar language on that Facebook page as in this letter. They go back to Miss Barlow and ask her if they know who Mr. Curtis is. They said no, yes, and his name was on that list. It was listed on the list of 100, and Miss Barlow says yes, we are aware of him. And they had additional email traffic that basically they had maintained email traffic that Mr. Curtis had sent to Mr. Wicker or Senator Wicker's office. I'm in the process of obtaining that from our Washington field office at this time. But in Miss Barlow's words and in the Capitol Police's words, they said, KC and I approved this message, and